Well, good morning. My name is Patty Backus, and I'm one of the members of the Board of Directors of the Broadband Institute. I am honored this morning to have the pleasure of introducing an inspiring scholar, activist, and thinker, and we at the Broadband Institute are thrilled to have her here to speak about reconciliation and about rebuilding the legal traditions and respecting Indigenous rights and governance. Dr. Val Napoleon is the Law Foundation Professor of Aboriginal Justice and Governance at the University of Victoria. She's from Northeast BC in an area known as the Treaty 8 Territory. She is a member of the Saltel First Nation and an adopted member of the Gitxsan House of Luxan, Canada, and a member of the Ganada clan. Val is also the director of UVic's Indigenous Law Research Unit. Val teaches and publishes on Aboriginal legal issues, Indigenous law and legal theories, Indigenous feminisms, governance, critical restorative justice, oral traditions, and Indigenous legal research methodologies and property law. Please join me in welcoming Dr. Val Napoleon.
I'm so honored to share this time with you, and I'm really excited about the kinds of questions you're asking and the themes that you've set out to guide your conversations. So, what kind of future might we imagine together? What kind of public imaginary can we build? The power and the importance of imagining together was recently recognized by the political philosopher Charles Taylor. And he said that democracy in the Western world has been degraded to a point of crisis. So in the face of this crisis, Taylor argues that there has to be at least three things in place in order for democracy to be truly democratic. First, people must possess a sense that they can act together. And for this, they need trust in one another, and they need an imagination in which they can actually see themselves acting together. Second, people need a repertoire of language, stories, and collective actions from which to draw in order to create social coherence. And finally, people need a social imaginary that allows for democratic conflict and a sense of civility that limits the violence. So such is the power of collective and public imagination. So I'd like to begin by introducing my youngest grandson, Elijah, and his best friend, Cielo. They're both the same age, just at opposite ends of the percentile chart, and I really love this picture. So I wonder, what kinds of conversations will they have in 20 years, 30 years, 40 years? Let's go with a 20-year time frame. Imagine, what will they be saying? Let's begin by imagining that both Cielo and Elijah are graduates from the currently proposed Indigenous Law degree program at the University of Victoria. This means that they would hold dual law degrees, one in Indigenous law and one in Canadian law. And they would have studies in selected Indigenous legal orders. For example, they might have a legal education in Cree criminal law, Dene tort law, Anishinaabeg constitutional law, Coast Salish civil procedure, Tsilhqot'in contract law, Gitxsan property law, along with corresponding Canadian legal subjects. So this is one of my paintings. I paint tricksters. These are grandmother tricksters. They're ravens. And they're Indigenous feminist ravens, born of the regeneration of Indigenous feminism around the world, and as a way to push back the way that a lot of people talk about tricksters, which is mainly as male these days. So both Elijah and Cielo would have a profound understanding of Indigenous peoples as lawful. In Elijah's case, of Cree and Tsimshian law, peoples being lawful. In Cielo's case, as Indigenous peoples from Guatemala as being lawful. Tsimshian law, Cree law, and so on would simply be a part of the world's great legal traditions. They will never have lived in a time where Indigenous law has been denied, or undermined, or distorted. So from this strong foundation, Elijah and Cielo would relate to other citizens in BC, in Canada, and the world. The BC that they would be a part of would be fully multi-juridical, and they would be capable of seeing legal precedent in oral histories, stories, songs, art forms, literature, and language. They would both be skilled Indigenous legal practitioners with flexible and nimble minds able to move across and between legal orders. They would be similar in this regard to students in Quebec who move between civil law and common law. They would be able to draw on Indigenous and non-Indigenous legal resources and principles to reason through the whole complex of human problems that every society experiences. They would have a deep temporal understanding of both historic and contemporary legal institutions and law. They would be able, with that temporal understanding, be able to reconcile the differences and contradictions and changes that are a necessary part of living law. Elijah and Cielo would know that each legal order is a comprehensive order with a full range of law that's necessary for managing all of messy, collective human life, from governance to family, to lands, to trade, to harms and injuries, a comprehensive system of law for each Indigenous society. And they would know that law is a distinct mode of governance for each Indigenous society, along with economic, political, and social ordering. The economic ordering would draw from Indigenous economic principles rather than defaulting to capitalism without any other imagination. These young people would not expect Indigenous law to be a quick fix to conflicts or problems, but rather would understand that Indigenous law takes as much hard work and time as any other system of law. The work of Indigenous law, as with any other system, is to not just know what the law is, but to know what to do when the law is broken. This means that the legitimate processes and accountability, those conditions of legitimacy and authority, have to be a part of the work. They would know that in BC and in Canada and elsewhere, the aspirations of Indigenous law at a minimum include community safety, fairness, and inclusion. And they would know that all law in its best form would include human dignity and agency, and that these would be the basic requirements or standard for any system of law to actually be law. So if we step back from that vantage point a little bit, in 20 years from now, what might the Highway of Tears look like? What might the issue of missing and murdered Indigenous women look like in 20 years? So it's another part of the imagination. I hope that Elijah and Cielo will be able to celebrate the restoration of lawfulness and the kind of violence experienced in our communities and outside of our communities, I understand as a condition of unlawfulness. So I hope they can celebrate lawfulness and the rebuilding of Indigenous law in our communities, and that this is from the ground up way to end gendered and sexual violence and the conditions that allow it to be a part of Canada and BC. In our work through the Indigenous Law Research Unit, we've been drawing on the work of James Tully, and part of what he sets out is what he calls practices of freedom or practices of citizenship. And it's based on an understanding that all around us are relations of power. And we're a part of those relations of power, navigating them, whether we're in power or not. We are trying to survive them. We do this by trying to operate within the rules. Sometimes that's the only safe place there is. We do this by trying to negotiate the rules. Think of all the different agreements that groups are always negotiating. We confront the rules. Think about litigation. Think about blockades. And we act otherwise. Think about rooftop gardens. Think about the small boys camp and other forms of resistance where people have stepped outside to find other ways to govern themselves. So these are relations of power, and all of us, from wherever we are, have the choice to either sustain and perpetuate rules of relations of power where they're oppressive, or we can find ways from whatever position we hold to change them, whether we're a teacher or a social worker or a prison guard, no matter what we're doing. We do this work in every Indigenous community that we work with. We ask people to set out and to think about what it is that they are doing. In part, it's a way to deal with conflict so that people can see that even if they disagree with how someone else is working, they're part of a whole. They're part of a whole way that people are trying to work in the best way that they can. So it's a way of bringing out what everyone is doing without initially trying to figure out which is the right way, and that the later measure is, again, whether we change things or whether we simply perpetuate them. And continuing with, again, the work of James Tully, this is work being done in Latin America, and this list is put together by Fauna Foreman, who has been working in Bogota, Medellin, and a number of other cities, Tijuana, and so on. And there's some, I'm sure a lot of you know about it, there's very inspiring work of transforming cities. So Medellin, for example, was the most dangerous place on the planet. And it's been transformed to a place that's safe. It's not without problems, but there's been fundamental shifts that have gone on in that city of about 3 million people. They did this by generating public thought, conversations, and space where knowledge can be generated collaboratively. They did this by rethinking governance, by turning governance institutions into think tanks, and by focusing on civic engagement and investing in creating a public life and building public trust. So fundamentally, they've zeroed in on collective human behavior, but also individual human behavior, in helping to shift from unhealthy norms to those that are healthy, and to looking at behavioral patterns and personal actions within those larger kinds of behavior patterns. So, you know, the three pieces of work that's set out here are similar to the kinds of things that have been discussed this morning. I think it's reconstructing the political, and I think it's redesigning governance, and I think it's re-spatializing citizenship. There's so many things here that are important, not just for Indigenous communities, but for non-Indigenous communities. So, for example, how might we understand this process for our communities, our tiny little Indigenous communities, and in cities and urban areas where we are a part of those urban populations? What are the issues of scale that we have to consider, and mobility, and other kinds of political and legal and economic issues, so that we can go through from the ground up transformation, which at a very small scale, which has been taking place on such a large scale in other parts of the world. Whoops. Sorry about this. I'm trying to go back to the picture of Elijah and Cielo. It's okay. You saw the picture. So, what I want for Elijah and Cielo, who reside in this province, I want this kind of reimagination of what's possible to be a part of their futures. In the work, in the work that we're doing with Indigenous law at the University of Victoria, we work in partnership with Indigenous communities, mainly across BC, but across Canada as well. We draw from the oral histories, from the stories, from other resources, Indigenous legal thought and how they've been recorded through the centuries. And we analyze those systematically, we synthesize them, and we create resources for those communities to deal with lands and resources, with governance, with child welfare, with other kinds of things that are a part of all of our collective existence. And those are also resources that we're hoping to be able to use for teaching the Indigenous law degree program at the University of Victoria. So it's about an intense democratization of law beyond, and it's rethinking democracy itself, I think, is part of the work, and moving from simply representative democracy to imagining other forms of civic engagement and inclusion. And we can democratize law as one way in to that democratic process. So here's to their future, and thank you for the time here.